If you're the author of a creative work, your ownership of that copyright is automatic, subject to any employment agreement that says otherwise. You don't have to register the copyright with any authority unless you choose to. It can be a useful thing to do. You can, for a fairly small amount of money. You don't have to use the little C copyright symbol on a creative work in Canada, not under Canadian law, but it is the case under some foreign laws, so it's generally a good practice to do so. Copyright lasts a long time. In Canada, the law is it lasts 50 years past the death of the author. And that's a good thing because it means that copyrighted materials can continue to generate revenues for a long time, even into the estate of the author. It's different in different countries in the world. In the United States, up until recently, it was 75 years past the creation of the copyrighted material. And recently, the US Congress extended that from 75 years to 90 years because a very expensive and valuable piece of intellectual property was about to lose its copyright and go into the public domain. That was actually Mickey Mouse, because the first cartoon containing a little animated mouse that looked like Mickey Mouse called Steamboat Willie occurred sometime in the 1920s, and Disney was about to lose its copyright on Mickey Mouse. So they rushed through Congress to extend the copyright protection for another 15 years because, as you can imagine, the image of Mickey Mouse is worth millions and millions of dollars to print it on t-shirts and to make cartoons and so on and so forth. Protecting software is an interesting and complicated case. When you copyright software, you're protecting the written code, but you're not protecting what that code does. Now, you can protect what that code does through a patent application in some cases, if what you've done is very new, useful, unobvious, and all the criteria of patent law. Now, a lot of people don't apply for patents on software for very good reasons. Number one, patenting is very expensive, tens of thousands of dollars to get a patent to issue. It takes a long time. Typically, it'll be several years before your patent will be examined and issued. And by the time you get this patent out, whatever software you've written may no longer be relevant, it may be obsolete, it may be solving a problem that doesn't exist anymore. So whether or not you just copyright, or whether you keep software secret, keep the source code secret, or whether you patent, depends very much on what your strategy for commercialization is. If, for example, you're trying to start a company and you're trying to interest venture capital or private investors in your company, you may want to patent because the investors will want to see that there's a physical asset protected to the intellectual property, that is a patent application or an issued patent. So it really depends on a lot of factors, and you have to look at really what you're trying to do and probably get some external advice as to the right ways to protect intellectual property and software products.